Therefore, Fogle would like to remind this court that he has never offered a waiver of this right, and at this point exercises his rights to challenge subject matter. This amicus humbly submits this brief and requests that this court make a record entry, perform a finding of facts, to either support defendant's lawful convictions as required to be in adherence of Article 3, or in the fact finding show that no such evidence exists to support such powers, rule accordingly, and dismiss all charges, releasing defendant from federal custody. Didn't he plead guilty? Hello everyone, I'm Leonard French, your favorite copyright attorney, and I got a good one for you today. You may remember Jared Fogle of Subway fame. You know, the Jared Fogle that pled guilty to 2 counts of offenses involving distribution and receipt of child pornography, as well as some other offenses. The district court imposed an above-guidelines sentence, a sentence above the sentencing guidelines, of 188 months in prison, which is about 15 years. Fogle appealed his sentence. The 7th Circuit Court of Appeals decided that the district court did not err in imposing an above-guidelines sentence. So, Mr. Fogle has been sitting in jail, and he has been trying to figure out what to do. Well, he figured it out when he filed this motion to correct clear error, and let's see how many of his ridiculous arguments we can discover and talk about over the next few minutes. What do you think? Comes now filing pro se, no lawyer, defendant Jared Fogle does hereby motion this court to address clear error as to the subject matter jurisdiction over these proceedings. Jared Fogle has rights to proceed before this court pro se. The issue of concern has neither been raised by his prior legal advisors, possessory, nor the district circuit courts. Fogle is raising his own this time. Timeliness of motion with a Y. As this court knows, subject matter jurisdiction is never waived. We must fulfill our independent obligation to assure that federal courts have subject matter jurisdiction throughout the proceedings. What is subject matter jurisdiction? That's another good question. Subject matter jurisdiction is the court's power over the subject matter, power over the crime. The appellate court is required to consider subject matter jurisdiction as the first question in every case and must dismiss the suit if such jurisdiction lacks. Issues of subject matter jurisdiction are never waived and can be raised at any point in the proceeding. Therefore, Fogle would like to remind this court that he has never offered a waiver of this right, and at this point exercises his rights to challenge subject matter. For purposes of this motion and for the sake of judicial economy, defendant Fogle, in pro se, does hereby rely on document 106, pages 1 to 23, filed September 21st, with this court. The arguments raised but not heard are now a record, and raise the clear and obvious error of want of subject matter jurisdiction, no end quote. Relief requested that this court perform a Rule 52B clear error correction. Note that a challenge has been made as to subject matter jurisdiction by Jared Fogle, require the United States of America to bear its burden of proof, base that burden of evidence from the records of the proceeding, and nothing ancillary. Enter a final decision on the facts and conclusions of law for the purpose of finality doctrine, with 2 R's, provide Fogle a copy of this court's findings. In summary, defendant Fogle asked this court to address 1. His newly and personally raised challenges to subject matter jurisdiction under the authority of Rule 52B of the Federal Rules of Criminal Procedure, rely on the existing brief on file noted at document 106, which we are reading next, require the United States of America to enter a responsive pleading, provide a hearing to defendant Fogle on the findings and facts as enumerated, finalize the decision on the records for the purpose of appeals, provided Fogle with a copy of the findings. Jared Fogle thinks he is a sovereign citizen and thinks that the court does not have jurisdiction over the subject matter of his criminality. No, I have no idea how he gets there. I read the first few pages of this and decided to stop and roll the cameras. Comes now, filing in pro se. Frank Edwin Pate does hereby motion this court to enter for the purpose of challenging the subject matter jurisdiction over defendant Jared Fogle the following brief. Frank Edwin Pate relies on standing to file this brief based upon the court and its ruling in these proceedings prior to sentencing, quote, in which a party is inadequately represented, as noted on the record. This court found that Mr. Fogle, hereinafter referred to as defendant, was adequately represented. Defendant contends this finding on the grounds that it is basic legal practice to check for subject matter jurisdiction. However, neither his lawyers nor the appellate court lawyers raised this point to the court. Due to the national exposure of defendant's case, this court's finding on the subject matter jurisdictional challenge hereby entered would have a direct impact on the like challenge to subject matter jurisdiction entered by Frank Edwin Pate in the Fifth Circuit and the Eastern District of Texas. Under Article 3, the court is required to make a findings and facts report as to the lack of subject matter jurisdiction in defendant's case. This would then influence the cases of Pate and anyone else filing similar motions. If you aren't laughing your ass off yet, that doesn't make any sense. Almost none of that makes any sense. Let's just really quick go back. First of all, standing is whether you have a concrete injury that can be remedied by a court, that is recognized and remedied by a court. So he just says standing and then goes on and talks about something else. He says that Mr. Fogle has rights to be adequately represented, but doesn't actually point to any place where he was not. He says that there was no finding of subject matter jurisdiction, but he also doesn't point to a proper challenge or any facts that support a subject matter jurisdiction challenge. Remember, subject matter is very, very basic. Does the court have the power over the subject matter? In this case, the criminal court prosecuted him for a criminal offense. So yes, Jared Fogle, the court has jurisdiction over you. Relief requested that this court grant this amicus the right to present the following arguments forward toward defendant's actual innocence of crimes as federally charged. According to Black's Law Dictionary, personal jurisdiction is a court's power to bring a person into its adjudicative process, jurisdiction over a person's rights, rather than merely over property. In any given district court in the United States, personal jurisdiction is currently alleged under Title 18 U.S.C. 3231 as signed into law by President Harry S. Truman on the 25th of June, 1948. Quote, original jurisdiction. A court of original jurisdiction has the power to hear the case for the first time, as opposed to appellate jurisdiction, which is the power to hear an appeal from a court of original jurisdiction. Additionally, all federal courts are bound to inspect subject matter jurisdiction as to assure that a crime has actually been committed. This is also known as the doctrine of standing, as required by Article 3 of the United States Constitution. No, subject matter jurisdiction is not also known as the doctrine of standing. Those are two different things. Subject matter jurisdiction is the power of the court over the subject matter. Standing is the court's recognizing of the party as having actually suffered an injury that's recognizable at law and remediable at law, that you can actually get a remedy at law. If you do not have standing, you cannot bring a case. But there are other reasons why a case would be dismissed, such as subject matter jurisdiction. These are separate things. When a court finds itself reviewing a charge in which subject matter lacks factual evidence, wanting, then a court has no choice but to dismiss the case, for the court then lacks in Article 3 authority, lacking in evidence over a specific offense. In the Law of Federal Courts, Charles Allen Wright said, "It is a principle of first importance that the federal courts are courts of limited jurisdiction. The federal courts cannot be courts of general jurisdiction. They are empowered to hear only such cases as are within the judicial power of the United States, as defined in the Constitution, and have been entrusted to them by a jurisdictional grant by Congress." Subject matter is defined by Black's law as follows: the issue presented for consideration, the thing in dispute. It is clear and evident that the legislation of law has passed by Congress will provide us with our direction as to what constitutes a crime. Another important and first matter in checking for jurisdiction is to assure specific intent to commit a crime exists, the intent to accomplish the precise criminal act one is later charged with. The Fifth Circuit Court of Appeals offers the following findings. When a federal court acts outside its statutory subject matter jurisdiction, it violates the fundamental constitutional precept of limited federal jurisdiction. The importance of both the lower federal court's constitutional and statutory subject matter jurisdiction should not be underestimated. Where Congress gives the lower courts jurisdiction over the certain controversies, due regard for the rightful independence of state governments, which should actuate federal courts, requires that they scrupulously confine their own jurisdiction to the precise limits which a federal statute defines. This is clear and supportive. In layman's terms, courts are to be focused only on what Congress tells them to police, nothing more, nothing less. The Supreme Court offers more guidance on the issue of the sovereign party's ability to exercise authority. We've got the first use of sovereign. But whether a judicial judgment is lawful depends on whether the sovereign has authority to render it. I'm going to guess that we're talking about sovereign nations there. Jurisdictional, quote, trigger. In order for a federal court to have a case in front of it, the plaintiff is required to provide proof of standing. This, of course, triggers and allows that Article 3 authority to be invoked through this court's controlling law. The federal courts are courts of limited jurisdiction, and we have an obligation at each stage of the proceedings to ensure that we have subject matter jurisdiction over the dispute. When a case or controversy is essential to the process of law, a case becomes moot, and the federal courts lose subject matter jurisdiction when a justiciable controversy ceases to exist between the parties. Grounding the mootness doctrine in the Constitution's Article 3 requirement, this case requires that courts adjudicate only actual ongoing cases or controversies. In January of this year, the Circuit Court found in Bubala v. Time Warner, which I don't know if that's a criminal case. He might be mixing up criminal and civil law here a bunch. An ingenious academic exercise in the conceivable, but as we have said, requires that at the summary judgment stage, a factual showing of perceptible harm must be evidenced. I don't even know what to make of that sentence. We're just going to continue on. In other words, when a party is seeking a favorable judgment, they must provide evidence of the offense as charged or claimed. This issue is not only an ongoing problem for this court, but an ongoing problem for the entire federal court system. According to the circuit in May, the courts must fulfill a check over jurisdictional power. We must fulfill our independent obligation to assure that federal courts have subject matter jurisdiction throughout the proceedings. In almost every case reviewed for this motion, the courts fail to mention this point. Yet is it not the key factor which must always remain independent? If not, then anyone can come to court under an assumed harm and get a judgment. Let me make a distinction for you. Article 3 standing applies to civil cases. The plaintiff is a civil plaintiff. We do not refer to the prosecutor as a plaintiff, and the prosecutor does not have to have Article 3 standing. The prosecutor has to have subject matter and personal jurisdiction and all that. This just mixes up civil and criminal law. When a defendant challenges the factual existence of subject matter jurisdiction rather than the sufficiency of the complaint itself, no presumption of truthfulness applies to the plaintiff's allegations. In other words, don't believe anything unless it can be proven by factual evidence. This circuit held in February of 2017, the appellate court is required to consider subject matter jurisdiction. I think we get it. I really think we get it, guy. In the instant case, no such evidence from the opinion of the same Seventh Circuit Court was offered on the records of defendant's case under direct review process. Whew. The Supreme Court found in Brandite's dissent, which is not precedential, quote, experience should teach us to be on guard to protect liberty when the government's purposes are beneficent, when the government benefits. Further, the court found the greatest dangers to liberty lurk in insidious encroachment by men of zeal, well-meaning but without understanding. It is defendants' belief and fear that the failure to examine in detail matters of subject matter jurisdiction is an example of the very behavior of which Justice Brandeis spoke. Defendants' jurisdictional violations, both of the charges laid down against defendant, require elements of proof to sustain a conviction. Most importantly, of course, is the requirement for subject matter proof. Defendant's charge states a person who travels in interstate commerce. Defendant spent over 200 days a year traveling at the behest of Subway, his then employer. The statute then addresses the subject matter element of this charge for the purpose of engaging in any illicit sexual conduct with another person. It is important to note that traveling itself is not illegal. The government did not bear its burden of proof that defendant traveled for the purpose of engaging in any illicit sexual conduct with another person. Defendant traveled to New York City at the behest of Subway, his employer, for the purpose of representing Subway at the New York City Marathon. This has been a task given to him by his employer, Subway, for multiple years and is proven by the submitted evidence of receipts for travel expenses that defendant was required to submit to his employer for reimbursal. Reimbursal. None of those receipts show any reimbursement for sex. This displays that his purpose for travel was his employment, not illicit sexual conduct. Now wait a second here. Didn't he plead guilty? I'm really confused, guys, here, because if he pled guilty, why would he be appealing that he didn't have a chance to present or that the government didn't present evidence in his case? Of course, the government doesn't have to present the evidence. You pled guilty. Whatever. Was defendant's conduct, engaging in sex for money with someone under the age of 18, illegal? Yes, clearly it was, and defendant made no attempt to state otherwise. Okay, so even Frank Pate here or whatever is saying that he did it. Was this conduct accessed by the statute as written by Congress? No. It could not have been unless the subject matter of travels in interstate commerce for the purpose of engaging in illicit sex conduct with another person was established and proven through factual evidence. Yes, if you hadn't pled guilty, they would have had to prove that. Yes, that's correct. If you hadn't pled guilty, let's come in close, guys. If you hadn't pled guilty, then yes, they would have to prove their case. That's what a guilty plea is about. And the hope is that you get a favorable sentence and a sentencing recommendation and all that from the prosecutor and judge for having entered a guilty plea instead of going through with a trial and losing. Subject matter jurisdiction can never be conferred to the plaintiff nor waived by the defendant. Congress's authority to confer jurisdiction upon the federal courts is limited by Article 3 of the Constitution, which extends only to cases and controversies. Yes, in civil cases and controversies. In order for any federal court to hold Article 3 authority over defendant on his charge, he would have to actually and concretely violated the federal statute by way of traveling in interstate commerce for the purpose of engaging in illicit sexual conduct with another person, which he pled guilty to. If, in fact, that were true, then defendant's employer could have been considered a conspirator to the charge. Subway, however, was not considered a conspirator. Oh, God. He's trying to make a fact by omission. Because they weren't charged, that means that they were not considered a conspirator, and because they were not considered a conspirator, that meant that defendant could not be a conspirator. No. Subway, however, was not considered a conspirator because defendant's business manager ordered his trip to New York City for the purpose of representing Subway at the New York City Marathon, which is provable by facts from the parties noted. This fact shows that the United States prosecution failed to supply this court with evidence defendant's illegal travel for the purpose of engaging in illicit sexual conduct with another person. If plaintiff had applied the principles of law as written, defendant would be criminally liable for the violation of New York state laws regarding his criminal conduct and not prosecutable under federal statutes. His conduct, although admittedly illegal, is not punishable under the legislation of 18 U.S.C. 2243b. Article 3 authoritative powers in this case have never been constitutionally accessed. So for reference, here is the Constitution. There's Article 3. The judicial power of the United States shall be vested in a Supreme Court and in such inferior courts as Congress may, from time to time, ordain and establish. The trial of all crimes shall be held where the state where the said crimes have been committed, but when not committed within any state, the trial shall be at a place or places as Congress may by law have directed. Lacking in a specific violation of 2243b, the district court also lacked Article 3 authority over defendant's stated illicit sexual conduct. In order to access federal jurisdiction, defendant would have had to travel across state lines for the purpose of engaging in illicit sexual conduct with any person. Defendant did no such thing. He traveled for the purpose of representing Subway in the New York City Marathon, and his receipts as were submitted to his employer will prove. After he stepped off the plane and commenced his job functions, he was not within the federal court's jurisdiction for any conduct that was illicit. Defendant will not argue that his affair with the young lady in question was illegal and immoral. However, is not the crime of charge, nor does it belong to the federal government. In support of this argument, D.C. District Court found in May 2017, appellant has presented only a journally available grievance that does not confer standing, citing Lujan v. Defenders of Wildlife, a civil case. This also rings true in the case of defendant. He was found generally guilty of illicit sexual conduct with any person because he traveled in interstate commerce. No, he was found guilty because he pled guilty. In 2014, the Supreme Court held that because appellant failed to establish standing, the district court properly dismissed the case for lack of subject matter jurisdiction. The United States established that defendant engaged in illicit sexual conduct with a person. Defendant is in no way attempting to avoid responsibility for that fact. Really? He is repentant and wishes that his punishment may lead to other potential offenders thinking twice about their conduct. This, however, does not change the legal fact that the plaintiff failed to supply the required proof that defendant traveled for the purpose of engaging in said conduct. All supplied evidence points to the fact that defendant traveled for the purpose of representing Subway at the New York Marathon and for nothing more. In May of 2017, the D.C. District Court found that a plaintiff was not entitled to access Article 3 powers. Again, a civil plaintiff. The above-mentioned case was against President Donald J. Trump. I'm pretty sure I haven't heard of a criminal case against him yet that's been filed, so it must have been a civil one. In this, the court found that the alleged injury was not sufficiently in evidence, as Congress allowed for such access to federal courts based on the working of the statute. Here, the court made sure that the statutory construction was adhered to strictly as it was written. Well, yes, trying to sue the President of the United States for anything except an actual injury you suffered because he personally did something to you, you're going to run into standing issues because that's exactly what standing is. You have to show that you are the person that was injured by his personal actions. If you are a person who was injured by his official political or governmental administration actions, that's not the same kind of standing, and you probably don't have the cause to sue him personally, if sue anybody at all. Because guess who is sovereign? The government is sovereign. The states are sovereign, not Mr. Jared Fogle. Now, the only thing I agree with is that none of us are here by choice. We were never asked if we wanted to be born. That's it. Does that make us sovereign over the government? In an anarchic world, maybe somebody could make that argument, but I am not on board with that. We need to live in a civilized world. I get that. And even if that does mean that we can't go around willy-nilly doing whatever we want, and even if that does mean that our government can get out of control sometimes, that doesn't mean that we can go around declaring ourselves sovereign and doing whatever the hell we want. End rant. Where is it written in the statute? Justice Gorsuch asked. This was his opening question as a Supreme Court justice, and it was delivered to Mr. Chris Landau as a check against Mr. Landau's interpretation of the statute to his benefit. Later in oral arguments, Mr. Landau commented that he was not attempting to change the law. Justice Gorsuch shot back, no, just making it up as you go, right? Purpose, as defined by Random House Dictionary, is the reason for which something exists. 2243B allows for federal provisions over illicit sexual conduct only if the travel in interstate commerce was for the purpose of engaging in any illicit sexual conduct. This requires that some measure of proof be provided to verify that the travel was for the stated purpose. Defendant had no such purpose in mind. He traveled at the instruction of his employer, Subway Sandwiches, for the purpose of representing Subway at the New York City Marathon. Just as in President Donald J. Trump's lawsuit in May of 2017, defendant's district court must dismiss for lack of standing pursuant to the lack of Article 3 requirements as clearly and unambiguously stated in 2243B of Title 18. I wonder if he thinks if he repeats Article 3 on standing in 2243B enough times, the court will just give in, because he's actually not fleshing out many of these arguments very well at all, right? 2243E, attempt and conspiracy. According to the records, defendant attempted and conspired to commit an offense of 2243B. Defendant asserts that this finding is in error. How could defendant travel to cities dictated by Subway for the purpose of representing Subway and at the same time travel with Taylor and also travel for the purpose of engaging in illicit sexual conduct? If Subway sent defendant to engage in representation of the company, how can he also be traveling solely for the purpose of engaging in illicit sexual conduct? Prostitution is illegal in most states. It is a state violation. Travel with intent to engage in illicit sexual conduct is a federal violation. Defendant admitted to his sexual misconduct while away on travel for Subway. State offenses. Defendant traveled over 200 days a year at the behest of Subway, and during that time, his life and daily appearance were under the domain and control of his employer. The purpose or intent of his travel at that time was not his own to dictate, therefore it is impossible for him to have traveled with any other intent than to represent Subway. Wow. Defendant made a choice, as bad as it may have been, to engage a prostitute. He did this of his own free will during a rare down period between professional appearances. Defendant will fully state the same. Mens rea requires that the travel be proven for the purpose of illicit sexual conduct. Lacking in such, the government lacks in the necessary element of standing and therefore jurisdiction. The United States further accused defendant of receiving and distributing child pornography. Additionally, as noted in the appellate court, a charge is laid over 2252 of conspiracy. Defendant contends the charge of conspiracy, not contests, he contends it. The United States was required to prove that defendant knowingly and willingly received and distributed child pornography. There was neither mention of defendant requesting such, nor does evidence presented show otherwise. Yes, because he pled guilty. There is no trial when you plead guilty. The affidavit to search defendant's home was not enacted until some 50 days after Russ Taylor was arrested by the state of Indiana. The probable cause for this search is still unknown. However, it appears that Taylor, facing massive charges, began to attempt to mitigate his exposure by dragging defendant into his sordid sex life. Taylor sent 2 pictures to defendant's cell phone. Appeals Court 7th Circuit recognizes this in their opinion. What is of most concern is that the pictures found on defendant's phone never traveled across state lines. Taylor and defendant live in the same city, and the phones were merely a few miles away from one another. Also, there was no element of commerce in the picture transfer. Those are key elements of which the courts are to address on their own. Yet it appears that not only did the appeals court ignore this, they actually create a semblance of jurisdictional implication where one did not exist. Any visual depiction that is illegal must travel in interstate commerce to invoke federal jurisdiction. Nothing on defendant's case notes any such fact-finding was afforded to him at either court level. Yes, because he pled guilty. Furthermore, in commerce would require that the visual depictions were sent across state lines for economic benefit. Federal jurisdiction requires that both aspects be proven. The United States simply cannot infer guilt of a crime. Guilt must be, in fact, proven. You think maybe your guilty plea proves it? Proof is a key factor, and in defendant's case, proof of the federal government's right to assume jurisdiction is lacking at almost every turn. This course of reasoning which leads to this conclusion is simple, obvious, and admits nor requires little illustration. There's a great sentence. You want the court to do something for you? Talk down to them. The power of the general governments are made up of concessions from several states. This is federalism. Whatever is not expressly given to the former, the latter expressly reserve. The judicial powers of the United States is a constituent part of those cessions. That power is to be exercised by the courts organized for that purpose and brought into existence by an effort of the legislative power of the Union. Of all the courts which the United States may, under their general power, constitute, on only the Supreme Court possesses jurisdiction derived immediately from the Constitution and of which the legislative power cannot deprive it. In other words, this court and district court may not simply make it up as they go along. The United States may not simply offer a plausible theory of violations. They must provide proof of standing by way of evidence showing an actual injury in fact in order to evoke Article 3 powers in the courts. In addition, no court may simply waive the importance of subject matter jurisdiction. This amicus humbly submits this brief and requests that this court make a record entry, perform a finding of facts, to either support defendant's lawful convictions as required to be in adherence of Article 3, and to ensure his constitutional rights are protected, or in the fact-finding show that no such evidence exists to support such powers, rule accordingly, and dismiss all charges, releasing defendant from federal custody. Signed, Frank Pate. I'm assuming this is the prison at Quincy Avenue in Colorado. Well, the judge denied that. Defendant Jared Fogle's frivolous pro se motion to correct clear error pursuant to Rule 52B, docketed at 110, is denied. Fogle challenges the court's subject matter jurisdiction over him. On November 19, 2015, Fogle, represented by retained counsel Andrew Richard DeVoit, Jeremy Margulis, and Ronald E. Elberger, entered a plea of guilty to and was sentenced on Count 1, conspiracy to receive, distribute child pornography, and distribution receipt of child pornography, and Count 2, traveling and attempting to travel in interstate commerce to engage in illegal sexual contact with a minor. On July 1, 2016, Fogle's conviction and 188-month sentence were affirmed on appeal in United States v. Fogle, 7th Circuit, 2016. The law provides that the district courts of the U.S. shall have original jurisdiction exclusive of the courts of the states on all offenses against the United States under Title 18 U.S.C. 3231. The district court clearly had subject matter jurisdiction over Fogle's criminal proceedings. In challenging the court's jurisdiction, Fogle states that he relies on Document 106, which is a motion to enter amicus curiae brief filed by Frank Edwin Pate, an inmate at the same prison where Fogle is housed. Pate's filing contends the district court lacks subject matter jurisdiction over Fogle and states whether a judicial judgment is lawful depends on whether the sovereign has authority to render it. If Fogle is now claiming to be sovereign, the Seventh Circuit has rejected theories of individual sovereignty, immunity from prosecution, and their ilk. See United States v. Hilgeford rejecting the shop-worn argument that a defendant is a sovereign and is beyond the jurisdictional bounds of the district court. See United States v. Schneider describing defendants' proposed sovereign citizen defense as having no conceivable validity in American law. See United States v. Phillips dismissing jurisdictional arguments as frivolous because federal courts have subject matter jurisdiction and personal jurisdiction over defendants brought before them on federal indictments alleging violations of federal law. The Seventh Circuit has instructed that these theories should be rejected summarily, however they are presented, in U.S. v. Banabi. Regardless of his theory, Fogle's challenge of this court's jurisdiction is rejected and his motion to correct clear error is denied. So ordered, Tanya Walton Pratt, United States District Court Judge, Southern District of Indiana. So what do you think of that craziness? Mr. Fogle made one last Hail Mary attempt to get himself out of jail after he admitted to his crimes and I guess is just looking to stir the pot, wants to have another trial for the fun and expense of it. Why, Mr. Fogle? You admitted to the allegations. You pled guilty. You had 3 lawyers that you paid for. What's up, man? I'm disappointed. But then again, I was already disappointed. Whatever. So that's that. What do you think of that? Let me know your thoughts in the comments below, on my Discord channel, on Twitter, or anywhere else you can find me. I'm Leonard French, your favorite copyright attorney. I would definitely like to thank my Patreon supporters for the month of November, not the least of which is Mr. AVE himself, who has sponsored a video on the Milwaukee versus Snap-on Tools patent judgment, where Milwaukee alleges that it was the original patent owner for lithium-ion tool batteries capable of 20 amps plus discharge continuous. Thank you as well to my $50 plus supporters. They are John Steele, Westin, Lohne, Nate Beck, Lydia Collinson, and Gavin Barnard. Thank you very much for your support in the month of November. Thank you as well to the $5 plus supporters that are scrolling on the LED panel behind me and are in the description below. So thank you all for joining me. Let me know what you thought of that. Once again, I'm Leonard French, your favorite copyright attorney. I'll see you in my next video, and I hope you have a great week.